bringing together voices in child and youth healthcare. This is CAFC Presents.
CAFC would like to thank the following member organizations for their generous support of our knowledge translation activities: the IWK Health Centre, the Children's Health Foundation of London, and the McMaster Children's Hospital Foundation. We would also like to thank the following Keystone partners for their ongoing contributions that support all of CAFC's programs and activities:
Hello, everyone, and welcome to today's episode of CAFC Presents. My name is Doug Maynard, and I'm the Associate Director at CAFC, the Canadian Association of Pediatric Health Centres. And welcome to today's webinar titled, When Families Go to Court for Care. I'm really excited to introduce today's topic, as I think this is really one of the things that makes the CAFC Presents series so interesting, and that we get to talk about some of the things that often don't make it onto the radar screen for many of us in the child and youth healthcare community. Sort of a chance to get our heads out of the usual clinical issues, and in this case, talking about sort of legal issues that impact care for children and families. We did talk quite a few months ago about the pro bono legal program partnerships at Sick Kids Hospital and the Children's Hospital at London Health Sciences Centre, and there's lots of interest in that topic. So this is a great opportunity to continue this type of discussion. So it's my pleasure to introduce three presenters new to the CAFC audience, I believe. Sheila Jennings, first, is an Ontario-trained lawyer and currently a full-time doctoral candidate at York University's Osgoode Hall Law School, where her research concerns the legal rights of children with severe disabilities to support. Kiran Pohar Manhas is a postdoctoral fellow with the Alberta Centre for Child, Family and Community Research and the Department of Community Health Sciences at the University of Calgary. Kiran has degrees in pharmacy, health research, law, and bioethics, and her doctoral research examined the qualitative, legal, and ethical implications of transitioning young ventilator-dependent children from hospital care to complex pediatric home care. And then we have Brendon Pooran, who is the founding lawyer at Pooran Law Professional Corporation, and he's involved in a number of areas of the firm's practice, but including disability law. And he's also, in addition to being a lawyer, Brendon teaches critical disability law at York University. So we've got a great panel with extensive knowledge in both the legal and healthcare fields, in community and disabilities, et cetera. So I think it's going to be a great discussion. So it's my pleasure to hand the virtual podium over to you, Sheila.
So to start, our objective in the presentations today is to introduce some of the forums that parents who provide care to children with complex care needs appear in when care issues are in dispute. Any one of the slides I show today could form the subject of a lengthy discussion on its own, and my talk is really to provide an overview of families going to court for care. I aim to promote discussion of some of the forms of support for caregiving that parents seek, and which may ultimately become the focus of an adversarial proceeding. The situations we will mention today underscore the reality that public policy offerings are too low for families with children with complex care needs, and that parents are challenging decisions respecting allocations of funding to them in respect of care, and are doing so internationally and not just in Canada. This means that, in addition to the struggles parents have with low levels of assistance with caregiving for children with complex care needs, they may also have to deal with the stress, time, and cost commitments associated with bringing claims to various tribunals and courts. Before we begin, it's important to delineate the children that are under discussion in our conversations today. So, children that we are referring to include children with physical, developmental, neurological, and/or psychiatric conditions requiring health and social services beyond those that are required by typical children. And in having the conversation today, it's important to recognize, too, that there have been developments in medicine with numbers of children living with complex care needs having increased as a result of advances in treatment following very premature babies having been born, as well as children born with severe impairments and children who have experienced serious accidents and trauma living longer, as well as children with genetic differences surviving conditions that they used to not survive. So in our discussions today, what do we mean by care? Primarily, we're looking at care that comes under two different domains of law. One is public law. Parents go to court in the domain of public law seeking respite, seeking home care, seeking funding to support caring. For example, in Ontario, they might use funding through disability services through DSO to pay for a PSW, for example, to come to the home to provide care. It includes short breaks, such as treatment centers that are accessed through child welfare services. It includes specialized foster care. And within public law, though we won't be going into it in much detail, there are actually many jurisdictions. There are each of the individual provincial and territorial jurisdictions. So there's great variability across sectors there. And there is also the federal jurisdiction in public law, which includes First Nations children with complex care needs. The other domain that I will be speaking to is private law. And in private law, parents will seek support, and it is primarily mothers who seek support in private law. And of course, there's a relationship as to the reasons why they do that to low offerings under public law. So parents will go to court to seek child support for a child into adulthood or a minor child with complex care needs. There's case law where a parent will go to court seeking spousal support to pay for respite, including, for example, a full-time working parent. There are parents who brought applications to vary access, to increase access, to have access in family court matters, provide respite. And then another area which we can discuss at the end, I'm not presenting on today, is the issue of shared care, which bridges public law and private law, which arises in the setting in Ontario in particular, where child welfare may actually have a temporary wardship agreement of a child with complex care need, and yet there's very extensive active parenting going on in the background as well with one of the parents. So, excuse me. So those are the two primary domains to describe what we mean by care, in quotes, today. So the next question is, what do we mean by court? So we are using the term to mean adjudicative bodies where parents bring appeals and claims, though there may also be mention in the course of our discussions of places where complaints are lodged, such as the provincial ombudsperson or the child advocate office, or for example in BC, the child and youth representative, who at the current time I believe is Mary Ellen Turpel. So turning first to the issue of child welfare court, excuse me, many Canadian parents in need of care for their child with complex care needs have found themselves in child welfare court. As well, a disproportionate number of children with complex care needs end up in the care of child welfare agencies. And this has been well documented, particularly by scholars in Manitoba. The latter may have come about as a result of parents having been served with a child protection application and or because they are seeking state assistance in the care of their child on a voluntary basis through child welfare provisions. In Ontario, for example, this is done through a finding under the Child and Family Service Act, with the finding being one of abandonment under Section 37 in the child protection legislation. And this latter feature has been a very contentious policy matter over the last number of years. And the practice really came into being in around 2000 through a policy directive. Now I think I've gotten ahead of myself. Okay, sorry about that. Okay, so the case that I'm going to be discussing with respect to child welfare court speaks to this issue of something that we've been witnessing, and I'm sure that listeners have seen it in the news. It happened very recently in Ontario, with a mother taking her adult daughter to Queen's Park, not only to make a point, but to assert her need of and right to long-term care for her daughter. So an example from the case law that I came across was a 2010 case, which is Children's Aid Society, Region of Halton, and JA1 and JA2, JA1 being the mother, and JA2 being the father. And in this case, a desperate Ontario mother took the party's 9-year-old to a hospital emergency room and left him there so that would trigger child welfare involvement, and therefore she could access needed care. In this case, the pediatrician stated that, and this is in the transcripts and it's in the decision, quote, "Mom is exhausted and has often come to my office crying. I don't believe these issues will be resolved solely on a week or weekend respite. As far as I'm concerned, this family has exhausted all forms of services that are available to children as severe as MA." And then the pediatrician continues on. One of the things to say about that evidence that was given by the pediatrician is that it's an example of the ways in which pediatric medicine is able to advance the rights of children through courts, through provincial courts. Ultimately, this child in this case was placed in a specialized group home, which was in fact the plan of care put forward by the Children's Aid Society and which the mother supported in her legal documents. The fathers opposed that plan. Child welfare cases, though dealing with public support, may intersect with domestic support matters, as occurred in this case. So in the background of this case, there was a domestic violence matter, so there would have been a criminal matter. And there was also separation, so there would have been a domestic family law proceeding taking place at the same time. So there would be 3 court cases going on simultaneously. And the last thing to say about this case is that prior to care, the care circumstances having broken down, not only was this mother providing care to this child and to another typical child, there were 2 respite workers and there was a grandmother. So there were 4 qualified adults participating in care, and still it was not sufficient to meet the needs of the child or the needs of the caregivers. So I'm going to move along to provincial tribunal. And so there are provincial tribunals in all provinces, and they all have slightly different names. Basically, families can appeal decisions made by provincial program directors excuse me, as to funding and care provision, and this is done initially internally within a given ministry, and if the decision isn't satisfactory to the parent, they can appeal that to the provincial tribunal. So an example of an appeal brought by a parent respecting Ontario's Assistance for Children with Severe Disabilities program is the Wood case, where the father of an 11-year-old girl, Grace, appealed a decision by the director of the funding program to terminate her benefits. It's quite remarkable to know that Grace's expenses in 2009 were approximately $23,000. And ultimately, the tribunal ruled in favor of Mr. Wood, stating that the income cap in the guidelines used by the administrator were in fact discretionary, and that under the circumstances, under the extreme extenuating circumstances of this girl's condition, that the cap could have been exceeded. And one thing that one sees is that income cap issues in the setting of administrative discretion are the subject matter of a great many appeals right across jurisdictions where parents believe the context of their child's situation was overlooked. Excuse me, I'm just having a little sip of water here. So just briefly to move over to the issue of dependency. A lot of these cases, the underlying feature or the underlying aspect of them that jumps out when you read them, regardless of whether they're in the public law domain or the private law domain, is the issue of dependency. And cases involving families going to court for care invite us to think carefully about the issue of dependency and the ways in which it is and is not dealt with in law. Family legal theorist Martha Feynman has researched extensively the legal implications and the implications for justice of unsupported dependency and vulnerability. In addressing the issue of care, many of the cases, whatever claims may be being made, reveal what she has termed derivative dependency. From cases where families go to court for care, we can see that families with children with complex care needs require and seek support from diverse sources in order to be able to effectively provide care. It is not only the child who is dependent on support. It is often the caregiver as well, who is most often the child's mother. As a result, it is more often mothers who bring family law claims to court for support, while it is more often fathers as child support payors who most often come to court with motions to vary or end support orders, or to defend claims mothers make for child or spousal support in the setting of the child with complex care needs. Though dealing only with some families with children with complex care needs, those with separated or divorced parents, the family law cases are valuable because they underscore that it is care that is often under discussion and not simply parenting. So if we turn to the WGB and CDR case, this case offers an example to underscore that same point, that what is under discussion is care and not simply parenting. So this case was heard in the Supreme Court of Nova Scotia, and here the mother applied to the court to vary access, visitation, which is time spent between of the father with the child. So she wanted to vary access through a court order between the child and the father. What she actually wanted was an order that the father exercise access, that he be court ordered to spend time with the child. And he refused. And so she sought to have the court order him to pay the costs of providing respite for her and for the child. And there are other such cases like this. And I wanted to note also that the issue of access in this setting, in the setting of separation and divorce, was tackled very nicely by Elaine Jones in New Brunswick in her MA thesis entitled Social Reality versus Family Law, the Experience of Mothers with Children with Long-Term Disabilities. And it's something that points to a particular vulnerability of single mothers with children with complex care needs. Child support claims are brought not uncommonly, it appears from what I have seen in the databases of case law, for adult children with complex care needs. And although I won't be able to go into it in any detail today, we could spend the whole webinar just looking at this one case. Vivian and Courtney is a case that's going on in Ontario right now. So in Ontario, claims for child support for children of married couples may be dealt with under the Federal Divorce Act or under provincial family law acts, while children of unmarried couples have to have their rights to support dealt with under provincial legislation. And this case involved an unmarried mother with a 21-year-old daughter, Jamie, who was receiving child support. However, when Jamie turned 18, her father sought to terminate her child support under the provincial family law legislation. In order to access child support for a child over the age of 18, the child must be enrolled in school full-time. Jamie attended an independent living education program, and related to her various medical conditions, she had to go for dialysis 6 days a week, which obviously would have had an impact on her ability to be a full-time student, which was the status required in order to be supported. The father's position was that Jamie was not in school full-time, and that support terminated on that occasion. His position was also that it is the state's responsibility to support Jamie as an adult, and we see that position reiterated over and over. It was seen in tort cases like Krangle and in other important family law cases like Sutherland and King. I mention this case to show that mothers and their legal counsel who come to court for care may find themselves having to convince a court to find a creative way not to have ableist child support standards applied and be determinative in family law support provisions that were not drafted with children with complex care needs in mind. And so to read more about this interesting case and important case, which also involves charter rights and freedoms issues, I'm providing a link here, and you can pull up that and read about what's happening with equality rights arguments there. So this slide has to do with an Alberta case, and I have to say that the judges in Alberta seem to really get disability. I don't know what that is. They seem to be ahead in the domains of child support and spousal support, and there are Alberta decisions which provide, they could be just articles in and of themselves, providing wonderful review of respite decisions across Canada for years, going back years. So claims have been made, as in this case, Caldwell and Caldwell, for spousal support in light of care primarily mothers provide, and in relation to their often concomitant inability to work full-time to support themselves. This is a recent case, and in 2014, at the Alberta Law Conference, a paper was presented called Evidence-Based Analysis of the Spousal Support Advisory Guidelines in Alberta. And in it, it was stated that a child with special needs can affect the ability of a primary parent to obtain or maintain full-time employment, meaning that the duration of support might be extended. And this same paper, based on the Caldwell and other decisions, asserted that child support paid, quote, may not properly reflect the recipient spouse's costs of caring for the high-needs child, end of quote. So this is a case of an award of spousal support in relation to a mother going to court for care, in particular for respite care. So it was an application to vary access brought by the mother. This case was very interesting because the mother's dependency wasn't really front and center. She was a nurse who worked full-time, and she cared for the party's only child who had 9 diagnoses, including intellectual disability. And the court stated that having reviewed the case law and the child support guidelines, they found that the child support regime did not contemplate respite care as a direct expense related to the child. And so they found for, instead, spousal support. Madam Justice Johnston in this case stated, I'm satisfied that the constant care of this special needs child warrants the provision of some respite to the applicant. Otherwise, the incessant demands on the applicant will not only severely impact her ability to care for AJY and her ability to advance her employment, but may even significantly affect her ability to maintain her employment. The judge invited the father to return to court with a plan to exercise access, which she agreed he was not ready, willing, or able to engage in at the time of the hearing. She stated, I am not persuaded that the applicant's desire, that's the mother's desire for respite care, is due to overprotectiveness, which had been one of the allegations made, nor am I of the view that the court should refrain from ordering spousal support to cover respite care in this case until the applicant reaches burnout. Taking such an approach would not be in anyone's best interest, including those of the respondent father. Now, I only have 5 or 6 minutes left, so I'm only going to gloss over this because I have 2 other cases I want to discuss. I wanted to just mention here that First Nations, through, for example, the First Nations Child and Family Caring Society, Assembly of First Nations, and individual band councils, along with mothers, there's the Sumner case, and there's this case, Maureen Beadle, and then there's a larger case that's taking place in the Canadian Human Rights Tribunal, are litigating around the issue of complex care needs for their children, and it would be really exciting to have a webinar just looking at that issue. It's legally very complex, and it's multifaceted as well. So this picture is Maureen Beadle, who, along with the Picton County Picton Band Council sued the Nova Scotia government with respect to her inability to get the amount of care that she needed for her son. The suggestion was being made that that perhaps he could be sent to an institution out of province. And this is a child who's very, very involved in his community, particularly with dance and music, and has a wonderful bond with his mother. So this case was actually brought in 2011, and the decision came down favorably in 2013. And the PDF link is there, should anybody care to pursue that. This slide here is the first of two slides, and my last two slides, which I am showing to underscore the point that the situation of families commencing proceedings for increased levels of assistance for children and youth with complex care needs has an international context. So this situation is a family in England, and this photograph is taken of a married mother, Jane Rocca, with her son James. James has cerebral palsy, severe autism, epilepsy, and a number of other conditions as well. So this case actually is one that falls under going back to the public domain. We've just been looking at cases brought in private law. Rocca has written a book called Standing Up for James. It came out in 2012. I believe the title of her book came from the words her husband Andrew spoke in the tribunal when they and their lawyer were making submissions to access care for James. Andrew stated, quote, "When James was born, I held my arms over his incubator. When he was diagnosed with cerebral palsy, I said to his physician, 'One day he will stand up and be counted. Today is that day,'" end of quote. And one can see from his comment that there is a parental perception that children with complex care needs may not matter in public policy as much as they ought to, and that they're entitled to have their needs legally addressed. Rocca, who had been a stay-at-home mother for a period of time, has stated, "At some point, the lawyer in me woke up again, and I started the battle of a lifetime. I wanted lots more help for James. I found that, although he had health, education, and social care needs, the problem was that the three departments were separate kingdoms, each with their own laws. If you did not agree with what they were doing or not doing, well, they each had their own appeal process, ... 5 years, 4 files of evidence, my MP, and an appeal to the Ombudsman," end quote. She sought respite care and placement in a school that provided social health and educational care. She has stated respecting her legal battle that, quote, "Similar battles are going on all over the country, and the government has recognized that this appalling situation must be addressed," end quote. Rocca has most recently been involved in giving evidence for changes to the Child and Family Bill in England, and part of her evidence is that, even with a legal background and supportive family, I have struggled with this system. I have proved in tribunal that James needs extensive care, including one-on-one supervision during all waking hours. Yet, I've had to continue arguing the case for his holiday coverage for 5 years without resolution, repeating the same evidence in one report after another. Her story is valuable as it sheds light on problems in the area of bureaucracy that parents encounter when they seek care, and such problems, if not resolved, may well lead to court. And this is my final slide. It is an example of an American family going to court for care. And the caption here is taken from the Tampa Bay Times, very recently, from May 15th, 2014. The photograph in the slide is of a 45-year-old single mother and her young daughter. The girl's pediatrician recommended 24-hour-a-day nursing care at home, and the state has offered 18 hours each weekday and fewer hours on weekends. And I guess this is a shortfall in this setting of this case. I believe that would be a lot of hours in Ontario. The news report from this link here, the news report reads that, quote, "Parents of severely disabled and medically fragile children battle state health administrators for nursing care services for their children. Without such care, some of the youngsters will end up in nursing homes, something the 10-year-old's mother is trying to avoid," end quote. In this case, the mother retained legal counsel to advance her claim that she was entitled to a higher level of state support Whenever you hear the word support, we're talking about care, and she had been accorded. And parts of the transcript for this case appear in the article. Under the heading of rationing care, this news report further states that Florida has consigned hundreds of children to geriatric nursing homes by eliminating the availability of in-home services that had been prescribed as medically necessary by a child's physician without reasonably considering the child's actual needs. The report further states that health administrators insist the state cannot afford to pay tens of millions of taxpayer dollars for the quote-unquote convenience of caregivers who have chosen to raise their frail and disabled children at home. As part of the cutbacks, one family was asked to have their 15-year-old daughter manage the ventilator. And the mother in this picture had her allocation of nursing hours cut back without the official having reviewed her medical file or inquiring into her competency or availability to look after the breathing tube. And these are also able and disabled child rights issues. So my take-home message is that the question that arises from the slides that I've presented are whose responsibility is it? We have systems that seem to be designed to push responsibility onto parents, and parents may be ill-equipped or unable or not in a position or not able to afford to cope with the level of responsibility that has been pushed onto them for any variety of reasons. And this is a justice issue, and I'll leave it to that. And thank you very much.
Thank you, Sheila. That's great presentation. Some great examples. I mean, it really sort of highlights, the breadth of the issues that are out there. So we don't have any questions right now, but that's my opportunity to remind the audience, type your questions in as you think of them, and in between presenters at the next break, we'll be happy to answer any questions, whether they be for Kiran, who's up next, or for Sheila. But in the meantime, we'll go on to our next presenter. Over to you, Kiran.
Perfect. Great. So I'd like to pick up where Sheila left off by looking at specific examples where families look to administrative law or the public law realm to argue for more support for their children with complex health needs. I'd like to, the aim is to talk about, in describing 3 specific legal cases and going into detail about the facts and the findings, I'd like to describe the implications of these cases for families, for the healthcare system, for healthcare professionals, as well as for the law. Before I begin, I just want to briefly introduce the legal category of administrative law, which Sheila gave a great intro, so I don't have to say too much. But generally, administrative law is that public law, and it governs the organization and operation of the executive branch of government. So we're talking about the ministries, the various ministries, and then their delegates, so their programs and boards, and it's the actions and operations, and also how they develop, interpret, and apply soft law, so policies and guidelines. So that's where the realm of administrative law. When children have complex health needs, they interact with the healthcare system as well as the social sector system if they're living at home in various different ways. And there are numerous programs that are involved, especially if we look at the Alberta context. There's different programs involved to offer different types of services. So there's the organization, the funding, and or the provision of different types of goods and services that families need. So this all encompasses the different forms of support and care for children with complex health needs, and that would be providing caregivers or the funding for caregivers, medical supplies, medical equipment, maybe some subsidization for housing or for participation in the community. All of these programs have different decision points where families might take issue with the decisions that are made, and it's that taking issue, which if it can't be resolved at the individual level, can sometimes escalate to a legal case or litigation. So the key administrative decision points would be eligibility. So programs decide if a child is eligible. Do they have the medical conditions, the requisite medical conditions that would fall under the rubric that they'd be eligible for support by a particular program? But we know that eligibility, extends to the family as well. So family income, as Sheila had pointed out, and also the request. So sometimes families come with specific requests, and the idea is that request covered within a particular program, or which program does it fall under? Once a child family request is deemed eligible, then the question becomes, And the decision is what level of support is provided, what level of support or funding, and then also the duration of support or funding. So there's reassessments, or there can be a deadline or expiry date. For example, for children, we often see at 18 or 19 is the expiry date when a particular program would stop providing funding. So we've seen families litigate at these various different points. The amount of case law within this realm is very low. So Sheila mentioned a great number of cases, but we know just generally disputes that make it all the way to court and to a final legal judgment are a much smaller fraction, a smaller proportion of the number of people who have issues, and that's because it takes a lot of time and energy to start and complete a legal claim. And we know that families who have medically complex children have, in particular, have many demands and burdens on their energy and time. So I'm going to look at 3 cases, and these 3 cases involved 3 sets of parent-child dyads, or little pairs, that went to court claiming that the home care they were was either inadequate or unavailable, and that level of inadequacy or the fact that it was unavailable was actually illegal and unfair. So they felt that there was room for the courts to come and intervene. One of these cases involved a child who's under the age of majority, while the other 2 cases involved offspring who are actually in their 30s, but the language of the parent-child relationship and parental obligations and family ties and the implications of that bond were predominant through the government's arguments and were tied into the argument of why they weren't receiving care, and then also in the language of the courts. So I feel like these cases, although the child is above the age of majority, they are very informative in this idea of families going to court to, whether the child is above or under the age of majority. So the first case is Dassenville-Trudel. So in this case, the child at issue was Dominique, a 9-year-old girl with severe autism spectrum disorder, and her care needs were considered to be extremely high and bordering on unmanageable. The family received some publicly funded support through the in-home support program for about a year, and their eligibility was very contingent on their family income. So mom was a lawyer, but she left full-time employment, and in doing that, she decreased the family income so that they were eligible to get public funding support. But later on, she took on some part-time consultant work, and that led to a reassessment. And the way the reassessment was done led to the family being disqualified. So that kind of triggered this litigation. The family went to the Nova Scotia Supreme Court, and they lost the trial, and then mom appealed to the Nova Scotia Court of Appeal. And so there are 3 big questions that they took to the courts. One was this income-based disqualification, which mom argued was made incorrectly and thus illegal. Then the next issue was that mom was requesting an intensive toilet training program and in-home security system, so she was asking for specific requests, and those requests were denied, and the reason for the denial was given that these specific requests were explicitly excluded by the guidelines, and mom argued that using that language, that was an unreasonable use of statutory discretion. And third, mom went back and forth with the social services sector and was requesting that they declare Dominique as a child in need of protective services if no additional funding was provided. She also indicated that she was not willing to give up custody of her child. She wanted that declaration because she wanted the courts to recognize and to have it recognized that without this funding, her child was in a precarious situation, and this request she felt was not fully considered and blanketly refused, so she felt that that was illegal and needed to be reassessed. So we can kind of divide the findings in each of the cases in findings that are more for the family and then findings that are more for the program or for government. So the findings that were somewhat victorious for family, I guess, would be the standard of review. So in administrative law decisions, when the courts don't want to intervene in policy decisions a lot, so when faced with a public policy decision at the operational, administrative, or the development level, courts first decide what standard of review they'll use to look at the decision, and so the level of judicial deference. How much will they defer to the expertise of the policy sector? And so the courts here didn't choose the highest level of judicial deference. They indicated a mid-level, which meant that they would look closely at the decision, and they would, at the beginning, decide that if they felt the decision was made wrongly, they would be able to say that and send the decision back. So using that standard of review, they found that with respect to the request for additional funding, that was an incorrectly made decision. So what they said was that the program guidelines did not explicitly exclude those additional requests, and in calling guidelines are not law. So in saying that a program is bound by guidelines is actually legally inappropriate, and the court talked about how we need to consider, and programs need to consider, the specific circumstances of the family and the child. So they said that this decision had to go back and be reassessed by the program, the in-home support program. Also, when looking at the family income decision, so what happened was that in 2000, when the family was originally eligible, Mom had worked for about half a year, and then she quit. And when they decided the eligibility, they didn't include that half-year income because she was no longer working that employment. Then a year later, when she took on part-time consultant work, the program looked back at that half-year income. They included it and actually extrapolated it for a full year, and then used that to claim that the family was ineligible. So the court recognized that that was inappropriate math, and that for one, and that also there needs to be a consideration in family income of the extraordinary care needs relative to income. So not just looking at a family income, but looking at that relative to care needs. So they quashed that decision as well and sent that back to government to reassess. Some findings that the other findings within the judgment are more, I think, on the side of government, and that was in sending back the request to about the additional funding request. The judgment is very clear that it is within ministerial discretion to say that we are not going to fund these additional requests, but it's not within ministerial discretion to say we can't fund because the guidelines say we can't. So they left the door very wide open and pretty much said this is how you can refuse it without, you have to redo the decision, but this is how you can come to the same result. And they also, the government found that it was reasonable because of that perceived maternal indecision about whether she wanted her child declared in need of protective services, and the indecision around whether to give up custody or not meant that the child was not in need of protective services. So that kind of cursory look at the situation was reasonable in the circumstances. Go to the next case. This is McQueen. In this case, we have a 35-year-old woman with cerebral palsy who was living in a 24-hour care institution, and her father had passed away, so she had decided to use her inheritance to buy her own independent home or dwelling. And the inheritance was enough to buy a home, but it wasn't enough for the support and care that she would require on a daily basis. She required 24-hour care at this institution. So she went to the Department of Health in Nova Scotia and requested home care support, but she was denied because she didn't have a care plan organized. So despite that denial, Allison went forward to move out of the institution, and with the help of her mother, she was able to live at home but was struggling. So after about 6 months, she initiated litigation, and she said that in just denying home care support because she didn't have a care plan organized, she felt that that was inappropriate, and she requested additional support, so such as a live-in support and support in organizing and attending social and recreational activities. So, not really a finding for the families, but upon initiating the litigation, the Department of Health reconsidered her request for home care, and they gave her some nominal support. I think she got about 3 or 4 hours each day of support with activities of daily living. So, but Allison felt that that was well below what she had originally requested, so she continued on with her case to the court. However, she didn't change her application. So when the judge looked at the case, he applied the doctrine of mootness. So he said, in this case, the issue was moot, or the issue was not alive, because she was claiming that the 2004 denial was what was done inappropriately, and because in 2005 they had a reassessment and she got some support, and that wasn't discussed in her original claim. So kind of a technicality, the court did not discuss the issue at all and move forward. Although I should note that the doctrine of mootness, when there's an issue of importance to public policy or important decision, courts can still litigate, or courts can still make a decision even though an issue is moot, but the courts in this case decided not to. We go to the final case, which is the Hutchinson one. This, we have a 35-year-old female with cerebral palsy who required 24-hour care. Since she had been 13, her father was her sole primary caregiver. About 6 years before the lawsuit, Cheryl was accepted into the Choices in Support for Independent Living program, which was a self-managed care program in BC, and the program is aimed at promoting autonomy and dignity and choice by giving people with disabilities giving them public funds and allowing them to find, hire, and pay caregivers themselves. So they have that choice. And so Cheryl tried 5 different caregivers, but felt that they each compromised her dignity, her mobility, and her security. So her father continued to be her sole and primary caregiver. However, the government policies and the CFIL agreement contained a blanket ban that stated that Cheryl could not use any public funds to pay her father or any relative for caregiving. So the Hutchinsons went to the Human Rights Tribunal in BC, and that decision, where they were successful, and then that decision went to the BC Supreme Court of Canada, or BC Supreme Court, and where they argued that the ban was discrimination on the basis of family status and disability. So the family was successful at both the tribunal and at the court level, because the ban was found discriminatory. It was found discriminatory because it was total, and it did not allow any consideration of skills or appropriateness for the job. So there was no room for individualized assessments. And so what this means is that bans can be appropriate and non-discriminatory if they're incomplete and allow exceptions. And the courts heard that there are other provinces where such exceptions are allowed, so they felt that having some tailored exceptions to the ban would not be an undue hardship for the provincial program to do. So in the end, the court ordered that the Hutchinsons, both father and daughter, would be paid for the impact on their dignity and lost opportunity for employment for the father. There were also, the court ordered that the CFIL had about 9 months to remove the blanket ban and develop exceptions to this ban for paying family caregivers, and also that they had to specifically allow Cheryl to hire her father as a CFIL funded caregiver at the average rate. So the average rate of payment about 8 hours a day. So he'd be paid not for all of his time, but for the time that an unrelated caregiver would work when families also voluntarily assist their family members. So in this case, it's more the language within the decision that is more of a finding for government. And the language of the court is very exceptional, and there's really an emphasis to try and limit the breadth of impact of this judgment. And the emphasis was just, you need to make exceptions to a ban, not remove this ban entirely. The emphasis was on the fact that the CSIL program was aimed at self-management, and this ban specifically targeted infringe the autonomy and the choice of the patient. There was also cost-neutral implications in the sense that the CSIL program was going to pay someone, so if they were paying Philip, it wasn't that in finding this ban discriminatory that the judges were moving into a legislative realm and forcing government to pay majorly more money. There's also a very small population of people who are eligible within this population, so the breadth of impact would be small even with that realm. And also the fact that families are only reimbursed at the level of the unrelated caregiver, not to their totality of care, is another way that they really emphasize the exceptional and limited scope of this judgment and what it meant. I'd like to go into some of the implications. So looking at these 3 cases is also looking just within the context and what Sheila sees. I think these cases demonstrate things. When we look at the implications for families, I think these cases demonstrate the power of litigation and the idea that if you have an intractable dispute, no one wants to go to court, but the idea is that if you feel like you're not being heard, there is something about getting a claim heard just by introducing a claim. As we saw with McQueen, just having her case reassessed because she lodged a claim in court. And then although courts really want a live issue, and then they can reassess. And courts take a very case-by-case exceptional approach, so they really appeal to exceptions to resolve disputes in this context. And looking to exceptionality and flexibility and case-by-case, even in the Destinville-Trudell case, about how looking at the specific needs of the family when deciding what additional requests are appropriate or not appropriate, and that kind of thing. The other thing is clear. that families should recognize is that the law and policies have a default position, and that is that families are independent and that families take care of each other, and that there's limited public support. So that we can see a lot in the Hutchinson case in the language where it's talking about if we start paying families, the government argument was that if we start paying families, then we're going to be, ripping the moral fabric of families because we won't, we'll be commercializing something that people should be doing on their own. So that's kind of the background there. I think implications for healthcare, if cases like these demonstrate some of the extreme burdens on families, the physical, financial, and social health of parents and children are implicated when they have children with complex health needs, and their care is very lengthy. It's a very broad and very deep responsibility that families have. And I think these cases also demonstrate that sometimes it's a choice between being home and having adequate care, but if it seems within the healthcare system there's a push towards deinstitutionalization and home care. If we're, these two things are in tension. This idea of being home and having adequate care, they should be the same if we're promoting home care. So that's an issue that we need to think about more. There's also, I think we have to recognize the need to exercise discretion when we're drafting, interpreting, and applying program policies. So no blanket bans, no blind application. We need to consider family needs and context. And discretion is not discrimination. So if something is discriminatory, which means there's an unfair treatment, so either we're treating people the same when they should be treated differently, or we're treating people differently when they should be treated the same, or we should be supporting people to be equal, then the courts are going to intervene more, and that level of discretion is inappropriate and will be found illegal if taken to court. And finally, implications for the law. It seems the law right now is doing what it usually does, going on a case-by-case basis, being reactionary because the courts are involved when there's an intractable dispute and people come to court to get their dispute heard, and it's also very discretionary. So the courts are very reticent to be involved in these policy decisions unless, again, they feel like it's something discriminatory and unfair because the courts are seen as the experts when it's unfairness and justice issues. But I believe that there's a need and there's room for legal guidance. For example, in the McQueen case, the idea, even just having judicial discussion about what would be fair and unfair, even if an issue is moot, would be informative to program policymakers and for families to understand, because all policies are developed within the legal context. And so having legal cases discuss what's appropriate and what's not would help us to move forward in developing programs that support families within a legal framework, so we can avoid this type of lengthy and burdensome and avoid disputes getting to this kind of level. So I'll leave it there, just so that Brendon can finish off.
All right, thanks, Kiran. Again, another great presentation. Really, some interesting things to think about there. It's just these cases are so sort of complicated and multi-level. It's really interesting. And CAFC has a community of practice around the medically complex child and trying to develop guidelines and that sort of thing. And we often hear from the families and the parents, how complicated their lives are, multiple service providers and all sorts of other issues that they have to deal with, perhaps surgeries, perhaps speech language therapists, occupational therapists, on and on, all of the complexity and the family left to coordinate all of that. And then if you layered on having to deal with one of these legal cases on top of that for these families, it's just an unimaginable burden. Do you have any thoughts on the impact on the family and how, even the thought of the family, the mother or the father, taking on all of this burden, and then in addition to that, activating a legal case or initiating some sort of legal proceeding on top of that because they feel there's a need. Do you have any thoughts around how the family would go about, overcoming that perception of the burden of adding even more to their plate?
I think it's a huge burden. So this work that I presented is in connection to my thesis, which also involves some qualitative work, talking to families and professionals about their experience of complex pediatric home care, and talking to moms. One mom said it perfectly, and she said, I'm just doing what I need to get by, and advocacy on top of that, I'd love to advocate for other people, but I just have time to advocate for myself. So sometimes, what I need to do, sometimes they fight for it within the system, and sometimes people just, if they can, will just find the support themselves, like, you know, fundraise themselves or through their families to be able to get the extra care support that they need. And those are lucky families that have that alternate avenue. But the idea of advocating on top of everything else it's a huge burden. And it's, you know, that mom has said, you know, when she's older, when my daughter's older and stuff, maybe I'll be more involved in other things. But right now, you know, it's just doing day by day and getting through it. So it's a huge burden, and it's very difficult. So I think that puts a burden on, you know, our healthcare team and our healthcare system to have those open avenues of communication so that we can recognize when families are close to burnout or, you know, the respite and the supports that are provided are inappropriate.
Mm-hmm.
So
all right. Yeah, no, thanks. That's great. All right. Well, we'll now move on to Brendon Pooran. Over to you, Brendon.
Thanks very much. Can everyone hear me okay?
Yeah, you sound great. Yeah.
Yeah. Okay. Great. So, good afternoon to some, and good morning to others. Thank you for inviting me to participate on this webinar here this morning. I've been asked to sort of discuss how the to sort of give you a practical walkthrough of what it looks like when individuals with disabilities and their families go to legal practitioners who are in private practice for assistance. So I've got a bit of an outline here today. First, I'm just going to give you an idea as to what the practice looks like. The main reason is just to sort of provide you with an overview of the services that we provide and to whom we provide them. There aren't too many, unfortunately, there aren't too many law firms in the Greater Toronto area, at least, or actually I would say province-wide, that really sort of focus on addressing disability issues. And so I'll give you a bit of an overview of that. And then part two of the presentation will basically is where I'll basically be walking you through the issues that we typically provide advice on. I'll start off by saying that we do everything in our power to dissuade families from litigating, especially litigating before the courts. And I guess dissuade's the wrong word, but what we really try to do is figure out a way to negotiate with opposing parties or with the relevant government entities to try and figure out a way to solve the problem when it comes to services and supports. As you've heard from our other presenters and from the question that was just addressed, it's a huge burden for families to have to litigate matters before tribunals and before the courts. Not only is it exhausting and a very time-consuming process, but it is also very, very expensive. And so there are a lot of access to justice issues that come into play. And more often than not, if individuals and families want to litigate matters, depending on the type of matter that they want to litigate, it's very difficult to provide them with an indication as to what the probability of success is going to be. And so to ask individuals to come up with financial resources to support a case without really knowing what the probability of success is going to be is quite difficult. So we do as much as we can to focus on the planning aspect to help families and individuals sort of create or come up with creative alternatives to your typical funding model. And you know, there are some very few cases, rare circumstances where we do get involved with litigation. So in terms of the practice, we almost exclusively focus on providing advice to the disability sector, with an emphasis in the developmental and mental health communities. We provide advice to individuals and families. So there are some law firms out there that may just focus in on the provision of advice to individuals. We kind of try to cover individuals and families, and as well as issues that affect children and issues that address adults. There's also part of the practice that deals with the provision of advice to disability organizations, so service providers, transfer payment agencies. where we act as general corporate counsel and take care of their labor and employment matters. And then with respect to government, what we try to do is we try to look at the type of advice that we regularly provide, develop some best practices, try to develop a body of knowledge, and then work with government around on various policy initiatives through outreach projects and different projects related to research and advice. What I'm going to focus on here today, obviously, are the issues that individuals and families come to us for. The first area, and I would say the most popular reason that families would come to our firm is for advice relating to estate and future planning. So what we're really trying to do is provide them with assistance related to promoting financial security for their relatives, for their sons and their daughters, and uninterrupted plans of care. We do that by developing estate plans to promote financial security. And one important aspect, probably the most important aspect of that, is setting up plans in such a way where inheritances to beneficiaries do not affect social assistance benefits. There are different income and asset rules, means-tested eligibility criteria that are applied to individuals when applying for social assistance. So we saw some cases, and I think in Sheila's presentation, that spoke to ACSD here in Ontario. There are some social assistance programs that focus on providing supports to children, and when we're talking about children, we're usually looking at financial eligibility from the family standpoint. But once individuals attain the age of 18, the means test that is applied to income and the asset rules typically apply to the individual only, or if the individual is married, then to the individual's spouse as well. So when we're walking through estate planning, we have to ensure that the estate plan includes instruments that allow for the individual to inherit from their parents' estates without it affecting eligibility for social assistance benefits. We don't come across too many families that have the financial resources in place where social assistance isn't going to play a key role in the children's future. Mainly because it's not only the income support benefits that individuals receive on a monthly basis, but in some cases, more importantly, it's the enhanced health, dental, and prescription drug coverage that comes along with these programs. There are also work-related benefits. There are disability-related assistance devices that individuals can access. There are housing benefits that individuals can access through these programs. So it's very important in most cases to do everything we can when deriving this estate plan to ensure that those benefits aren't affected. So the use of trusts in these estate plans is very common. Trusts are a way of ensuring that inheritances are protected from social assistance benefits. Now, the legislation, or the common law, does vary from province to province. So, one kind of typical trust that we use is something called the discretionary trust, or Henson Trust, which is available in almost all provinces across Canada, with one exception being Alberta. Along with trusts, however, come the added challenge for families, which is, who are we going to name as trustees? So who do we have in our lives that we trust enough to administer potentially tens of thousands or hundreds of thousands of dollars for the benefit of my child? And there are other factors that go into that. How well do they know the beneficiary of the trust? Are they sensitive to their needs, to their wants? Do they understand relevant social assistance legislation? How good are they at investing funds? Are they diligent enough and conscientious enough to account and to file annual tax returns? So, that's quite a discussion that we typically get into with families. Some of them have ended up asking us to act as corporate trustees, or they will ask trust companies or banks to do so. The advantage there is that there is always this entity in place to govern the trust and to administer it. The disadvantage is that the trust company or the law firm may not have a relationship with the beneficiary, and in addition to that, it's an obvious expense to the estate or to the trust. Sort of a topic that has become more common or more popular in I would say over the course of the last 12 or 18 months of the estate planning process is a discussion around housing options. So I'm not sure what the wait lists are like in other provinces across the country, but here in Ontario, I want to say that we have close to 10,000 individuals on wait lists around the province for residential options. And so families are really looking at legal practitioners or at other individuals in the sector to help them come up with creative housing options. So that's one thing that another aspect that we sort of work into the plan. And I would say overall, what we're really trying to do when we're working through this planning process with families is we're trying to help them connect the dots. The system is, for services and supports, is so disjointed from sector to sector, from the federal jurisdiction to provincial benefits, that we really try to bring that all together. So you've got your estate plan, you've got your provincial benefits, your federal benefits, your independent facilitation, your support networks. How do those all tie together? How do they relate to one another? That's really what we're trying to help them. Moving on to federal benefits. So we get quite a few inquiries around access to federal benefits. And with respect to both federal and provincial benefits, as you may already know, healthcare practitioners play an incredibly important role. They essentially act as the gatekeepers when it comes to the determination, determining whether or not someone's going to actually be able to access benefits. Much of the benefits that are administered are still based on a medical model of disabilities, and healthcare practitioners are usually the individuals that are authorized to make the call as to whether or not somebody has a long-term disability or not. Most of the federal benefits are derived through our income tax system. The most generous of these benefits was introduced by the federal government back in 2008, something called the Registered Disability Savings Plan that some of you may have already heard of. It is a very, very, very progressive income support program for individuals with disabilities. I would say probably the most progressive anywhere in the world, whereby the federal government will actually contribute up to $4,500 per year into an individual's registered plan. Think of it in the same light as a registered retirement savings plan or an education savings plan, whereby a long-term savings account is opened up by the individual that's registered with the federal government, and thereby it attracts quite a few benefits, including tax-deferred growth and these very generous government contributions that I mentioned. In order to qualify for this registered disability savings plan, the individual must be eligible for what's called the Disability Tax Credit Certificate. So many of you may have completed, or many healthcare practitioners out there may have completed the Canada Revenue Agency form called the T2201 on behalf of your patients. This is the form that would make them eligible for a wide range of benefits under our income tax system, including non-refundable tax credits, eligible medical expenses, disability support deductions, as well as making the individual eligible for a registered disability savings plan. Since the inception of the disability savings plan, we've seen that CRA pays or applies a little bit more scrutiny to these disability tax credit applications, and so often individuals are not successful on their first attempt their first attempt when submitting this P2201. As a result, there is an appeals process that people can go through. We typically provide some summary advice on appeals, and then refer matters out to either accountants or lawyers that specialize in appealing disability tax credit certificate decisions. At the federal level as well, and this, obviously wouldn't apply to children, but for adults, we see individuals in receipt of Canada Pension Plan disability benefits. And in the past, we used to do quite a few of these appeals before the Social Security Tribunal. Lately, we tend to refer them out. But that's sort of another area of law that we get involved with at the federal level. Moving on to provincial social assistance benefits, and this slide is very Ontario focused, given that we're based in Midtown Toronto, and most of our work really takes place in the province of Ontario and BC. There are a number of provincial social assistance benefits that individuals with disabilities are able to access. Ontario Works is our provincial welfare program. We don't do a whole lot of work in the Ontario Works arena, mainly because that program is geared towards individuals that may not have a disability that otherwise can qualify for the Ontario Disability Support Program, ODSP, which I'll talk about in just a second. There's rent geared to income housing that individuals can access, and there is assistance for children with severe disabilities, which was mentioned again in Sheila's presentation. That's the social assistance program for families that are providing care to children with disabilities. It means it's income tested based on the family's income, and I believe we don't do a whole lot of work in that area, but I want to say that families have to be earning under approximately $60,000 to be entitled to any type of support. Most of our work with respect to provincial benefits deals with the Ontario Disability Support Program. There are about 800 rules associated with the program, very difficult for even lawyers who practice in this area to understand, let alone individuals and their families. So we provide a lot of advice related to eligibility, not so much on the disability determination side, more so on the financial eligibility side. So how much can I earn from other income sources and continue to be eligible for ODSP? How much can I have in terms of assets? So how much money can I have in my bank account? Can I own a home? Can I own a car? Can I own a life insurance policy? Excuse me. And still be eligible for this program. So we deal with ODSP on a regular basis. Again, we try to negotiate sort of solutions on behalf of our clients to the issues that they are facing. A lot of the issues stem from inheritances that haven't been planned for properly. So trying to deal with restructuring inheritances so that the individual continues to qualify for social assistance forward. We do quite a few appeals. So when individuals apply for ODSP and they're denied, or they have been on ODSP and something triggers a suspension of their file or a termination of their file, there is an appeal route to the Social Benefits Tribunal that is available to individuals, and we often provide legal counsel there. We typically refer cases out to Legal Aid Ontario first. Again, this comes back to the access to justice issue. So obviously for individuals that are applying for social assistance benefits, they don't have a whole lot of resources to support a legal challenge. So if a legal aid clinic is willing to take on the file, we encourage the individual or the family to go that route first. If not, we do accept, we are in private practice, but we do accept legal aid certificates. So if the individual is able to get a legal aid certificate, we will take that on behalf of them. There are a few see legal aid as arm's length from the government, so they figure out a way to pay, not necessarily market rates for legal fees, but they come up with the resources to support the legal challenge. Again, with the Ontario Disability Support Program, much of the many of the cases in which we get involved with when it comes to someone not being accepted to the program for disability-related reasons, it comes down to the medical evidence that's been provided by the doctor. So we tend to work with doctors to ensure that they understand the legislation, they understand the legal test, and they're able to reflect that in the documentation that goes to the tribunal. Moving on, and I'll try to move a bit quicker. Moving on to provincial services and supports. Provincial services and supports, what I'm referring to here are any other supports that are available to children or adults with disabilities outside of our social assistance program. Social assistance is an entitlement program when it comes to the provision of supports. These types of services and supports are not. I would call them more of a discretionary benefit. And the unfortunate aspect of these other streams of funding is that there is no appeal process. There really is no formalized appeal route grounded in legislation that's available to individuals and families. So again, here in Ontario, for children, we may be talking about special services at home, which is funding that's provided for respite care and community activities for individuals under the age of 18. That benefit used to extend into adulthood, and as of last year, time's flying, I guess the year before, the government put an end to that. So they've cut off special services at home at age 18. We have a new piece of legislation that was implemented back in 2010. The shorter form is called the Social Inclusion Act. The long form, the long title for the legislation is on the slide. We get involved in terms of advising individuals and families with respect to a person's eligibility, to the changes in process when it comes to accessing these benefits. And then when it comes to contesting decisions, we take on very, very few of these cases these days, again, because there is no appeal process rooted in legislation. For the cases that we do get involved with, we're trying to negotiate some sort of outcome, some form of support for the individual, with usually involving the administrative community. Individuals and families may come to us with human rights issues, cases that are usually based on a protected ground of disability under the Ontario Human Rights Code. Protected areas include accommodation, contracts, employment services, and vocational associations. Most of our work here, again, deals with mediation. So we try to do everything we can to avoid having to go before the Human Rights Tribunal. It can be a long, drawn-out process. It can be a very expensive process. Legal aid, Ontario does not cover legal fees for human rights cases, and so we try to mediate outcomes on behalf of the individual. With human rights cases, we in the last few years we usually refer matters out to the Human Rights Support Center first, which is an arm of our human rights sort of framework here in Ontario. It's a publicly funded legal support center where individuals can go for summary advice on human rights matters, and in some cases, the center will represent individuals right up to the tribunal level. So we usually send individuals there first to see if they're able to get any summary advice or representation from the center. If not, we try to figure out a way to provide them with support related to their legal issue. Moving on to consent capacity and decision making. So this has become a very, very important issue that covers really all aspects of life. So when it comes to accessing financial supports, when it comes to accessing housing, when it comes to estate planning, when it comes to signing a contract, when it comes to making a will or granting power of attorney, the law around consent capacity get a lot of advice from individuals in the healthcare field, from individuals in the education sector and the government sector, and a lot of that advice conflicts. A lot of the advice presented is conflicting in nature, and unfortunately, a lot of the advice that's received is incorrect. So we'll typically, families will call us. They'll say, "My son or my daughter is turning 18 years of age. I've been told that I've got to go out and seek a guardianship order, or I've got to get power of attorney." And in 9 out of 10 of those cases, that's simply not true. The way our legislative frameworks are set up, going through, the undignified sort of process of obtaining guardianship is just not needed. So we provide regular consultations with respect to these matters. There are some cases where families do want to proceed with guardianship because they're just frustrated with the constant issues that they're faced with, or that they may encounter when they're trying to renew a health card, or when they're trying to seek when they're trying to open up a bank account, when they're trying to obtain information regarding healthcare matters. Some of them want to move forward with a guardianship application. We try to deter them from doing so for a couple of reasons. One is that from a human rights standpoint, the individual is losing all of their decision-making rights, and those rights are being attributed to somebody else. And two, it is a very, very, very expensive process. So here in Ontario, I would estimate guardianship to run anywhere between $5,000 and $10,000. When individuals come to us for appeals to the Consent Capacity Board, which is a provincial tribunal that deals with applications from individuals that have been involuntarily detained in a psychiatric facility or have been found to be incapable of managing personal care or property matters, we typically refer those matters out to the lawyer referral service or to legal aid. What we really try to do in this area of consent capacity decision making is a lot of outreach. We provide seminars on the topic to educate the public, to help educate the healthcare field, the government field, the educational field, and the financial sector as well, so that everybody has a sound understanding as to how these laws interact with each other. And finally, my last slide deals with self-directed support organizations. So often individuals and families will come to us, again, as part of their future planning needs. They may have individualized funding, complex special needs funding, let's say, that is being flowed from the government through a transfer payment agency to families in order to pay for services and supports. An effective and sustainable way of managing these resources is to set up a separate not-for-profit corporation that administers these funds. So we provide quite a bit of advice around the setup, the incorporation, the bylaws, and then the employment-related matters that stem from these types of corporate structures. That's all I have. Those are sort of the top 6 or 7 issues that we deal with and that we find individuals coming to us for advice. I would say in conclusion that you can see from the types of issues that are raised that healthcare practitioners do play a key role, do play an important role in the determination of benefits. So we try our best to work with healthcare practitioners to ensure that forms are filled out correctly in order for individuals to access the services that they require. Thank you.
All right, thank you, Brendon. Once again, I think this is a lot of information for people to digest. I think a lot of this is probably somewhat foreign to a lot of the audience, just as far as understanding that these issues are out there. But certainly, I think most people are not familiar with the level of complexity that's entailed here. I guess the one question that seems to be coming through is what's the role of the practitioner in, what would be your advice to the practitioners that are dealing with the family when they perceive that there might be a potential for a legal issue? Like, and this can go to any one of you. Feel free to jump in. But what would be your advice to the practitioners as far as supporting the family when there's a perception of a potential legal issue?
Am I heard?
Sure. Yeah, Sheila, go ahead.
Oh, okay, I was just going to respond to that question, and I think actually Brendon is a board member. Here in Ontario, we have now the Administrative Justice Care Network. So I guess if I was a healthcare practitioner, I might be inclined to direct the parent, if it was a support domain in the public domain, to go and speak to somebody at the Administrative Justice Care Network, because they're experienced in these sorts of appeals, and in whether or not, in fact, the matter that you want to bring as a complaint would fall within the jurisdiction of one of those tribunals.
Yeah, and that's a great point. And just to add to that, we do have a publicly funded legal aid clinic here in Ontario called Arch that specializes in disability issues. So often Arch is a good place to start in order to either receive some summary advice or to receive the appropriate referral. Again, if the matter deals with human rights issues, going to the Human Rights Legal Support Center is also a great starting point.
Mm-hmm.
I would just add, sorry, it's Kiran. I would just add that sometimes just from a clinical, like from a team level, because there's so many different sectors involved, sometimes it might be important to, one, maybe get the family to talk to someone else, like just because we all want to avoid litigation, but maybe to have I think lots of times families need to be heard and to be understood, and sometimes bringing in a new not a new party, but maybe someone else on the team who doesn't have as much interaction with them, so you can have a new voice, like new ears, listen to the family, and then maybe get to what the root of the issue is, so that we can kind of resolve disputes before they go to litigation. I mean, we want to support families and what they feel they need, but just being heard, I think, is important within the team.
All right. And going back to one of your slides, Kiran, you mentioned that one of the issues that was part of one of your cases was around the administrator of a program's interpretation or their guidelines that they had in place for interpreting sort of access to a particular program. And that you had that bullet that said guidelines don't equal the law. So many of the people in the audience here would be those administrators who are left with interpreting in some way a program and who gets access to it. Right? There's always some level of interpretation. What advice might you give to those administrators out there that are sort of looking to to not end up in trouble but being at the same time forced to interpret these laws in some way?
Well, I think the big thing is just interpreting it, not just blindly following it and blindly applying it, but interpreting it. And I think all three cases are clear that we have to look at the context, so the family and like the entirety of the child's needs and the family's needs and the request required. So not just looking at family income, or not just looking at they're requesting A, or they want to pay the dad kind of thing. So not just looking at the request, but looking at the entire context. Like, I think those are the biggest things. And then when describing rationale and having a clear rationale of how you're interpreting and how you're applying. So, just for your own thought processes in developing these, in developing the policies, and then in developing, and working as professionals in applying these guidelines, I think having a clear idea. So in that Daffenbell-Trudell case, it was the saying, I'm not allowed to do this because the guidelines say I can't do this, saying that my hands are tied. So just saying that, in that language, the courts will see that as people are treating the guidelines as law and wouldn't apply, but just saying that, my interpretation of the guidelines is that this doesn't fit what the program is meant to do, and then having more explanation. Like, I think, and I think if you do that detailed, thoughtful process, then you'll be able to find families the support hopefully you can find the families the support they need, but from not protecting yourself, but having a clear rationale of what you're doing, and, maybe going to the vision and the mission statement, that type of thing as support, if that makes sense.
No, that totally makes sense. I mean, it's really, about putting the patient and the family at the center, the family-centered care, as we always talk about in the child and youth healthcare world, and doing what's best for them, as opposed to applying a blanket statement across everyone, that one-size-fits-all thing. So,
yeah, I think that's the biggest piece. Sorry, go ahead.
Oh, I was just going to say that with respect to discretion, I'm not even exactly sure what information administrators of programs are given about when it's appropriate to use their discretion in any particular direction, or whether, in fact, there's pressure on decision makers not to exercise their discretion, or to keep awards down for budgetary reasons, because presumably those employed by these programs understand that they do have discretion. And they are trained in the guidelines. They know the difference between a guideline and a law. And so, one wonders whether there are other factors in play aside from just this notion that the guidelines are being interpreted literally as limits or limitations.
We are pretty much out of time. Sorry, go ahead, Brendon.
No, sorry, very quickly, I was just saying what we often find is that the frontline staff may not quite understand the discretion that they have to exercise, and so once elevated to a supervisor, to a manager, the level of understanding is typically there, and we're usually a lot more successful in negotiating an outcome if we do elevate it to that level.
All right. We did have a question come in. We are pretty much out of time, but we did have a question come in asking if the slides will be available. We do record these, obviously, and the audio-visual recording will be available. But is everyone able to share their slides with us?
Sure. Be happy to.
Yeah, I can share the slides.
All right. And then those will be, everyone does receive an email following this with a link to the page on our Knowledge Exchange Network where the recording and any slides or any other resources will be. So you will receive that email. It usually takes a couple of days to get that stuff up. So, but with that, I think we're going to have to close that off. We do have a few people are starting to drop off. People have to leave. It's been the full 90 minutes and then some, but we were just starting to get into a great discussion. I hate to end it here, but unfortunately, time is not on our side. So is there any final closing comments you guys would like to leave the audience with? Sheila, if you wanted to start with you.
I guess one of the things I think would be interesting for people to start having conversations about ways that we can get some kind of, with our federal-provincial split, it's very difficult to contemplate it, but some kind of national strategy conversation around national initiatives to address issues around inadequacies in assistance for heavily burdened caregivers. There are access to justice issues, there are financial issues, there are large numbers of caregivers falling into poverty, and I think it's a national problem in both the federal jurisdiction for First Nations families and in the provincial jurisdiction. I think there's a conversation that needs to be had with at the umbrella level.
Mm-hmm. All right. And Kiran, any final comments?
I guess just building on what Sheila said, and what we both said, the idea that very few families make it to court, and as much as when a lot of people come from the science background, and how generalizable are the handful of cases that we've discussed, and I think it's that there's so many system issues and family and care issues here that these disputes, I think, are very representative as much as, it's just a small number. So I think there's a lot of families that are struggling, and that we need to kind of, reassess how we're doing it. And we've all talked about the idea that there's so many different sectors and everyone's doing different things, that we need more cross-sector work, especially in this area of those complex things.
All right. And Brendon, any final comments?
Sure, just 2 quick points. Again, just to reiterate the important role that healthcare practitioners play in terms of the determination of an individual's benefits. So if any guidance is ever required, I would really encourage practitioners to seek that when completing the relevant application forms. And number 2, just given this economic environment that we find ourselves in, and the fact that the sector is so incredibly underfunded, I think we really have to
Well, I guess I'll just close by saying thank you to all three of you for such a great presentation. It really was enlightening, and I think an area that touches all of the healthcare providers that we deal with. But again, I think there's really no understanding of how deep these issues go. Like especially once these children leave the four walls of our institutions. So thanks for the great information. And as I mentioned, this was recorded. We will have it up in the next couple of days on the Knowledge Exchange Network. And we hope that you can join us next week when we talk about engaging hard to reach families in pediatric care. Not next week, June 18th. We're off next week. Sam's telling me we are in fact off next week. We don't have anything next week, but it's June 18th is our next webinar, and then we will be taking probably a hiatus for much of the summer. So, but you can always find the most up to date information on our website at cafc.org. If you just click on the CAFC Presents section, you can find all of the information about upcoming webinars and how to register and how to sign up for email notifications and all of that sort of thing. So, thank you again for coming, and we hopefully will see you on the next one. Bye, everyone.
Thanks so much.
Thank you. Bye.